Hi, I'm Stephen Kelly, the technical lead caseworker in the Advocates Graduated Fee team. Today, I'm putting out a video to go through how you would submit a claim for the Advocates Graduated Fee work on the Claim for Crown Court Defence system. Also, as part of this, we will be showing you new fees that have come about from the Criminal Legal Aid Independent Review. So just starting here, this is a demo version of the Claim for Crown Court Defence system that you as a fee earner would see at your end. So when you would come into the system, you would see the system as is showing now on this front page, and it would give you a list of outstanding cases or cases that have been previously submitted here. What we're going to do is we're going to take you through and start and show you how to create a new claim. So to do that, you would click on this Start Claim button here. Once you've done that, it'll bring you into the first page of creating a new claim. There, at the top of the page, there are some information that you'll be able to see, which gives you a few details in and around hardship claims that were introduced, changes made to hardship claims that were introduced on the 1st of May 2020, and also information around including a main hearing date for claims with a main hearing on or after the 31st of October 2022. And we'll touch on that in a bit more depth in a few minutes. You will then see this option here of all of the bill types that you have open to. The Claim for Crown Court Defence system, I'm probably going to call this CCCD for short throughout the rest of this video, is used by both the advocates and the litigators fee teams for claims and work that were carried out in the Crown Court. Now, today, the video is going to focus on the advocate side of things. As you see here, you have 4 options open. The vast majority of these will be the advocate's final fee type that you would choose, and that's the version we're going to demonstrate today. So I'm just going to choose that and move on. So the next aspect will show you a list of fee earners within your chambers, and you would select the fee earner that the claim was relevant for and who was the trial advocate on that case. Next is a reference number. Now, this is an internal reference number for yourselves and is not something that the LAA would use ourselves. But if it's helpful for yourselves to have that internal reference number on the case, please use that and put that claim number or internal reference number that you would use in this section. The next part will be to choose the case type of the case. You'll see here that there is a large amount of option of case types that there is within the Advocates Graduated Fee scheme. The version we're going to go through and demonstrate today is a trial, so I'm just going to select that. Next will be the court and the case number. So the court firstly, and you would choose the Crown Court where this case proceeded with. Now I'm going to use Manchester here, but obviously you would choose the relevant Crown Court for your case. Also then you would just give us the case number here. You'll see here a couple of different just rough examples of what the case number should look like. Now, this case number here that I'm highlighting is an example of a case number that you would see on our exhibit live system, that the case had went through the exhibit system within the courts. The other version you'll see here is a unique reference number, which will be relevant for claims that have proceeded with under the common platform system. We're just going to put in a random number here just as an example. The other aspect just to mention here is if the claim was to start at one court and transfer to another court for trial, for instance, we would ask if you could provide the later case number and also the later court where the trial took place. That just makes things slightly easier for us to make our assessment. We then have this final main hearing date. Now, this is really helpful for us if you were to include this because of the changes that occurred under the Criminal Legal Aid Independent Review. For a representation order that was dated before the 30th of September 2022, so for Scheme 12, that's rep orders between the 17th of September 2020 and the 29th of September 2022. The criminal legal aid independent review and work that came out of that increased the fees by 15% for these cases, but only if the main hearing occurred on or after the 31st of October 2022. So for the figures to generate the correct amount for those claims of the rep order that falls within those Scheme 12 dates, we would also need the final main hearing date to be provided. That will then generate the correct fees on both CCCD here and also within the LAA's internal billing system, so that we can make payments correctly at first port of call for yourselves. As well as cases under Scheme 12, we also have claims under Scheme 11 where the 15% increase is included also. That would be for claims with a main hearing on or after the 23rd of the 12th, 2022, which would also get the 15% increase in fees. You see here, just as I was touching on previously, if the claim was transferred, we would ask that the final court and case details be provided. Just great if you did have a claim that transferred court, that you give us the original court and also the original case number in this section. But for this example, we won't use that. And finally on here, we've got the trial details. So we've got the first day of trial that it's asking us to put in. So for this example, I am going to use the 9th of January 2024. And the trial concluded, as we'll have already seen from the final date of the main hearing, that included on the 15th of January 2024. And then it's just asking for the estimated trial length. On this, I'm going to put 6 days, and actual trial length also 6 days. As you can see here, we've got a couple of options. You can either save and continue, and that will just continue on to the whole process of submitting this bill. You can also save as a draft. So if you were to save as a draft, it would just stop the process at this point. The claim would then be showing in the front page that you've already seen, and you could come back to it at a later date. But on this, we're obviously going to continue and take you through the whole billing process and submission of that. So next bit would be the defendant's name and first name and surname. So if you could just fill in that for us, that would be really helpful. And also their date of birth. So obviously I'm just going to put some fictitious dates in here for us to have that. One of the things we would just say, it's really helpful if you can double check the details of the defendant's name and their date of birth. Reason being that if we weren't able to find the details for the case number, if potentially you'd made a typo error there, we will try and cross-reference based on the defendant's details, so their name and their date of birth, and that allows us to potentially find the case details in our systems if there was an error with the case details. So it's really helpful if you can just double check that and see if that's correct. Next aspect would be to just provide the date of the rep order. So we would always ask that you provide the first date that the representation was granted. If the representation was changed at a later date, it would be the earliest date that we would want within here, and the MAT reference number. So again, I'm going to just provide a fictitious MAT reference number, but we would ask again if you could just double check that when submitting the claim that the MAT reference is correct. The reason that we ask for that is the MAT reference that you provide will then automatically inject into our systems, and if it's incorrect, it will likely bring up an incorrect defendant, and we would have to amend that and remove that from the system. So it's really helpful if you can double check that and make sure the MAT number provided is correct. Next, you'll see that we've come onto the page with the offence details for the case. What you would look to do here is type in the basis of the offence. So on this one, I'm going to choose a rape, but you would type in whatever the offence was that you're having, and it will give you a large range of options here with the offence that you were looking for. You can also have, you will note here that we have this help with the offence classifications, and that gives you a link to our Crown Court fee guidance where you have a bit more detail that should hopefully be able to allow you to confirm and select the right offence for the case that you're claiming. Like I say, on this one, we're going to use a rape as the example, and we're going to select that and continue. Once you've done that, it brings you on to this next page, where firstly it will be asking you for the advocate category. We have here a junior, leading junior, or King's Counsel option open. The vast majority of the claims that are submitted to the Advocates Graduated Fee Team will be for junior counsel. And in the example we're using here, it's going to be a junior counsel claim that we're going to show. Is just being aware that if you do have a claim, though, for a leading junior or a King's Counsel, that we do require the extended representation order to cover for the three options that are open, are for a King's Counsel alone, for two junior counsel, or for a King's Counsel and a junior counsel. So if any claim is extended, the representation for that, we would ask that the extending representation order be provided at first submission, and that will avoid any unnecessary appeals or rejections at our end, because we do need that information to be able to process the claim for you. Once we've decided the category of the advocate, as we've done here, you will then see that it generates just a basic fee. So this is the basic fee that will be generated for a band 4.1 that goes to trial for a junior alone. You then will come down to the section where you have a few of the additional fees that are available to be paid on the claim. There are a lot of other miscellaneous hearings which will show on the next page. On this page, it just has a few of the options. Now, the first ones I'm going to go through is I need to add the daily attendance fees. For a trial, the first day of the trial falls within the basic fee, and we've got that date as being the 9th of January 2024. We know that this is a 6-day trial, so I'm going to need to add another 5 days to this trial. So we would just ask that you add all of the dates on there, so we know the dates that you're claiming, so we can correctly assess that. Now, on this example, you will see that the first day of trial, the first day that I'm choosing of the daily attendance fees is the 12th of December 2023, which is actually before the date we've put as the first day of trial on the 9th of January 2024. There is a reason for that. In the example I'm showing you here, it is one where a Section 28 has taken place. So in this fictitious example, a Section 28 hearing has occurred on the 12th of December 2023. Now, that Section 28 hearing is payable as a trial day, but it is not the first day of trial as laid out in the remuneration regulations. So for the purposes of who the trial advocate would be, it would be the normal trial start date, which in this example is the 9th of January 2024. So the counsel who attended on that date would be the one that would need to submit the bill and would be the one we put as the first day of trial. The 12th of December is payable as a trial day, but it's additional trial day rather than a trial start. I'm then just going to add the rest of the dates that we have for this example. Once we've added all of those dates, we then have the option of a few other fees, as you see here. So on this example, we're only going to show it having a plea and trial preparation hearing, but if it has a standard appearance fee, conference views, or defendant a case uplift, this would be the point where you would want to add those fees on. But as we've said, this is just going to have one plea and trial preparation hearing. So here you would just add the quantity and then just provide us the date, so we know the date that we are looking to review on this case. So once we've done that, we would then save and continue, and it would bring us on to the next page where we then have the miscellaneous fees, where there is a far greater amount of options of fees that are payable or claimable on a case. So you'll see here the large list of potential fee type option of miscellaneous fees that are available on an advocate graduated fee scheme claim. Now, we're going to use a few examples here of fees that have occurred as part of the criminal legal aid independent review. So the first one we're going to choose is a Section 28 hearing. So as we've touched on the previous page, we are aware that there was a Section 28 hearing that took place on the 12th of December 2023. Now that hearing, the Section 28 hearing, generates a fee of a daily attendance fee, as we've put onto the system on the previous page. It's, however, also for claim for the representation order dated on or after the 1st of February 2023, as well as the daily attendance fee that's payable for each Section 28 hearing that occurs, you are entitled to one fixed fee Section 28 hearing per case where a Section 28 hearing takes place. Now, if that as long as the representation order is dated on or after the 1st of February 2023. For claims that are after the 1st of February 2023, we have a fee for rep orders from the 1st of February 2023 to the 15th of November 2023, which will be payable at £670 plus VAT. If, however, your representation order is dated on or after the 16th of November 2023, that fee increases to £1,000. So that fee is payable per case, one per case, for any case where a Section 28 hearing takes place. So we have that fee now on here. We're going to just add a few more fees as well. The next one is another fee that has come about as part of the Criminal Legal Aid Independent Review, and that's a fee for an additional preparation fee. The fee is payable for any trial or trial case which occurs with a rep order on or after the 17th of April 2023. So any correct trial or trial claim that has a rep order on the case that was dated on or after the 17th of April 2023 is entitled to this £62 fee for an additional preparation fee. That is the only requirement that you have, that your original rep order is dated on or after the 17th of April 2023 and your claim is a correct trial or trial, then you are automatically entitled to this fee. And we're just going to show a couple of other fees. Now, these aren't ones that came about from the Criminal Legal Aid Independent Review and have been about a little bit longer than that. And these are our unused material fees. Now, any claim similar to the additional preparation fee that is a correct trial or trial, but crucially with these that has a rep order on or after the 17th of September 2020, is entitled to consider the unused material. Now, we have two separate sorts of fees. Firstly, you have the unused material up to 3 hours. This is a fixed fee, and this is payable for any of the cases with a correct trial or trial and a rep order on or after the 17th of April. So that's automatically payable if you meet that criteria. The next part is if your unused material time that counsel has spent on the case exceeds 3 hours, then we also have the fee of the unused material over 3 hours. So the first 3 hours are within that basic fee. Any time above and beyond those first 3 hours are payable at an hourly rate, as you can see here. Now, in this example, we're going to have a case where there's been 12 hours of unused material that has been considered by counsel. So we know the first 3 hours are in the basic fee. So then we would consider the next 9 hours would be payable at that hourly rate. Just a couple of things, though, to be aware of with unused material over the first 3 hours. If the claim is over the first 3 hours, firstly, it is a requirement that that you submit the claim with a completed AU1 form attached. If this wasn't received, we would be unable to process the unused material until that was provided outside of the fixed fee. As well as the AU1 form, also please be aware on cases where the unused material claim is over 10 hours. That 10 hours does include the 3 hours within the basic fee. So in this scenario, if it was 7 hours or over, you would also need to provide a copy of counsel's work log for us to consider. So for this example here, these are going to be the fees that we're add, but as you can see, there's many other options open to counsel for what you can claim, and you would claim that dependent on what happened with the case. The final aspect that we have here on this section is just confirming if you've previously been paid for an interim warrant fee, that you would confirm on here that that is the case. The very few claims will have had an interim warrant fee, but if you have, you would just confirm that for us. On this example, we're going to confirm that there has been no interim warrant fee and continue onwards. In the next section, we have travel expenses. So we have lots of different travel expenses open. Car travel, cab travel here. You have train, public transport. If you've stayed over in a hotel accommodation and subsistence, lots of different options. So you would just go through and select which one was relevant to yourselves. I'm not going to have on this example any travel claims, but one of the things we would advise, if you do have a travel claims and you need to give us any additional information, please do so we can try and make an assessment at the first port of call. For instance, as it says here, if you're claiming the private mileage rate, now our rates would be 25p standard rate and 45p for the higher private mileage rate. If you were to claim the higher 45p, we would ask that you just provide justification as to why public transport was not an option, so we're able to consider that when we're making our assessment. Also, if you were to have, for instance, you were claiming and travelling outside of the local bar, but you have some justification you want us to consider as to why that might be reasonable, please also provide that in the additional information section so we can consider that and make an assessment on that basis. Once we've saved and coming on to the next page, we then first have this question of where will you be sending electronic evidence for this claim? So that is asking, would you have things like raw phone data, something of that nature that has been claimed as pages of prosecution evidence for an AGFS claim? That's almost certainly going to fall within band 6 or band 9 and be part of the proxies that will make up the different offence bands within that. If you do have electronic evidence that is vital to claiming, you will be sending that to us. We would ask, it's really important to us if you could just highlight that as a yes rather than no. That allows us to make sure that the claim is going to the right caseworker who is trained in this area to be able to assess that first port of call. So it's really helpful if you could confirm that is the case. We would also ask that you log into the secure file exchange as indicated there and upload all of the electronic evidence files that are making part of the claim, so we can assess that at first sight and try and deal with that straight away for yourselves. The next part is just you uploading any additional files that you need to for the case. For any claim, a copy of the indictment will be a requirement if it's a case on indictment. So we would ask that you provide that, or we would have to soft reject and request that that be provided. But any other supporting information, please provide that to us so we can fully consider your claim and try and get the assessment right at the first port of call for you. Finally, you've got another additional information section here. The last one was just for travel. This is just for more widely in relation to the whole of the claim, and any information that you think will help us, really helpful for us to have it. We would rather have a little bit more information than we need than not enough, so that we can look at it and try and make an assessment at first stage and try and get things right for you. Once we've done that, though, we will then just save and continue. And it will then bring you into an overview of the system and everything that you have claimed. So you can, at this point, make any changes that you may feel are needed. If something's incorrect or you forgot to add something, you can make any of those changes at this stage. But if you're happy once you've reviewed it that everything is correct, you would then just go to save and continue again. And then it just brings you into the certification box as to why counsel is making the claim. Now, for any case with a representation dated on or after the 5th of May 2015, the only option open would be that counsel attended the main hearing, so making them the trial advocate. So if we look at that, if you have a guilty plea, it would be counsel attended the guilty plea hearing. If it's a cracked trial, it would be the date that the case cracked. And with relation to a trial, for the purposes of billing, the date that we would consider would be the first day of trial. So if in the unlikely event that counsel was to change during the body of the trial, we would be paying the fees to the counsel who attended on the first day of the trial. If your representation order is dated before the 5th of May 2015, then the regulations were different at that time, and you have numerous options open as to why you would be the instructed advocate, and you would select the one accordingly to why you consider yourself to be the instructed advocate, and we will consider on that basis. But once you've certified that, you then obviously have this page just explaining what you're certifying to. So we would ask that you just clearly read that and confirm that the certification is correct, and then you just come down and certify and submit claim. And once you've done that, the claim will now be confirmed that it has been submitted. You can then go back to your claims, and the claim will be the last one then showing that you've submitted in the system. So this one here is the example that we have having been submitted on this case. Now, at this point, I'm going to move over to some slides to do the rest of the breakdown of this video. So we will just move over now onto the slides. So now that the claim is submitted, this would be what you would see on your system. Once the claim had been allocated out, you should get a message on there that will advise that the claim has been allocated out to one of our caseworkers. Just one thing, just to be for awareness point of view, we do, however, occasionally use holding queues that will look the same to you externally as the claim being allocated out to a caseworker. That's very commonly used for our high value claims, so that's claims over £30,000, but it can be used for certain other cases as well. If you were to see a claim was being allocated out several days ahead of what our target dates say on the website, I would suggest the likelihood is that is what's happened. So if you just see that something's been allocated out ahead of time, or something's been allocated, then deallocated and allocated straight away again, the odds are that that's what's happened. We put it in a holding queue until the time that we've been ready to pass that out and assess that for the bill. So just for a bit of awareness there. Now, this here would be what would happen when the claim is submitted to our end. What we see at our end. So our end is very similar to yourselves, just with the additional option of being able to add some fee figures in there. So when we have a claim, if we were to assess things down, firstly, we will be providing a note explaining the assessment. So you're aware of any disagreement that we would have or additional information that we may need with relation to the bill that has been submitted. And once we've done that, sent that note, we would then advise the payment that we've made. So in this example here, we've just made a part assessment. So we're assessing down, giving you a breakdown of why, and then we'll put part assess with the figures that we've paid. And once we've done that, the claim will then be sent back to yourself. So you'll then see, as you can see here, that the claim is then showing in your system, but it is showing now as part authorized. So you have that part authorization there, and it will just advise that you have a message to come in view. So once you then would come into the claim, on this example, we're going to work on the basis that council does want to appeal the original determination that we had. So one of the issues that we are having in this fictitious example is that we were missing an attendance note for the hearing. And also we'd removed some of the unused time because we've been claiming scheduling time, which wouldn't be something that we would normally consider to be payable as unused. So here, council is just input the explanation for why they're appealing. Once you've done that, just send that and apply for redetermination. And as soon as that's done, then you'll see again, here is this claim there. And now it's showing as redetermination. So that means that it's gone back to our end and we have that claim and we're then ready to review that, but it will obviously be allocated that on a date received basis. So then sitting there until that goes to one of our caseworkers for them to consider. So again, once we then get it, we'll see the message from yourselves. We will allocate the claim out to one of our caseworkers, and they will then consider the further information. So an example we had here, happy with the additional attendance note, and we were able to pay further fees, but we upheld the decision we made around the unused material and sent the claim back at that point. So once we've sent it back, again, you will then get that note saying that it's been part authorized, and it'll tell you there's another message to consider. And then when you come into the system, then you'll be able to see the message that we have. And at this point, because there's already been a previous redetermination, you now have open to you three options. You can archive the claim. That archive option would have been available as well after the first assessment. You have the option of applying for a further redetermination, or you can request to go to written reasons. Now, from our perspective, and on this example, we have chosen the written reasons one to show you how to do that. The advice that we would give with relation to what to do at this stage, if you have further information that you want to provide that wasn't given for the first assessment that could help with the assessment and allow us to make the redetermination, then by all means at that point, please ask for a redetermination. We can look at that. If, however, we've used a redetermination already, and the issue is more of that we have a disagreement between ourselves, maybe based on the facts of the case or something, around how the facts they should be interpreted. Our position at that stage is actually the best option for yourselves is to request written reasons. What will happen there is first that'll go to one of our most experienced caseworkers and they will consider the full base of the case. And we would always ask, if you're requesting written reasons, please give us a very detailed breakdown of what the issue is at hand so we can consider that in full depth. If our caseworker looks at that and considers that you are actually in the right, we will obviously make payment at that stage and there will be no need for us to provide any formal written reasons. However, if our caseworker, on full consideration of the facts, still believes the decision made was correct, we can then provide you full and detailed written reasons to allow you to take the matters before a cost judge. So we would advise, if we get to that sort of impasse where there's just clearly that we're in different positions based on our interpretation of the facts, we would advise that written reasons is really the best option at that stage. Once we get that, we would then attach the written reasons and send that back to yourselves. So you would then see the written reasons having been attached. Once we've provided our written reasons, you do have 21 days on receipt of that letter to take the matter to the Senior Courts Cost Office. On any written reasons we provide, we will provide you a letter with the assessment we made, attach that to CCCD, and that explains our position and also exactly how you can go about taking the matter before the Senior Courts Cost Office. Now, at this stage, you can decide to archive the claim. If you want to go to the cost judge, that's absolutely fine. But if you were to decide, actually, I agree with the position put forward by the LAA on this occasion, that's the option you could have is to look to then just archive the claim. So on the example we're going to use here, we're just going to choose to archive the claim just to show you the full range of the system. So here we're going to then just click on the archive. Once you've done that, you'll see that the claim will then show in the status as archived pending deleted. So once you've pressed on that button, it will show then within your list of claims as archived pending delete. That will show within the system for a period of 16 weeks. So during that period of 16 weeks, you can unarchive the claim. And if you go back into the system, you'll see this unarchive option there. If you were to click that button, it then brings the claim back out of its archive state and will allow you to further redetermine or potentially request written reasons with the bill. If, however, you remain satisfied with all of that once you've archived it, the claim will remain there for 16 weeks. But after 16 weeks, the claim will automatically delete itself and will no longer be within the list of cases that you have there. If a case has not been archived and is left idle for 16 weeks, the system automatically archives it at that point itself. And then it gets the 16 weeks post that point before its deletion. So if you were to touch a claim and didn't archive it, it would actually be 32 weeks before it would be deleted from our system. And that there is an overview of everything that we wanted to go through today. So hopefully you will find that video informative and helpful. Thank you.